power of attorney for property is a very forceful document. It allows the agent of the patient to sign any legal documents. If a patient you think is entitled to some Social Security disability income payments and the patient is not together enough, his thought is too disorganized to apply for those payments, if you have an agency relationship under a power of attorney for property, you can do that. Once again, it requires the patient's signature, so you have to have cooperation with the patient, and it is easily revoked. This other document is something you should all know about if you have a family member with mental illness, the Declaration for Mental Health Care Treatment. It does also require the signature of the patient. And if you can get the signature of a patient, if you explain to them what this is, and when the patient is in a good place and feeling good, it's a truly wonderful document. It is a document that allows you to admit a patient against their will and treat a patient against their will, but not indiscriminately. A doctor has to review, complete, and sign this form. The doctor will say just what medications the patient should be taking. So, and sometimes this makes the patient more comfortable knowing that you're not just going to be able to give him any medication, you're just going to be able to give him medication that this doctor has thought to be beneficial to him. It only lasts 3 years, but it's irrevocable. The patient cannot revoke it. It's a very strong, wonderful document, and if anyone's interested after this session, I'd be happy to tell them how they can get the document. Lastly, I want to talk about guardianship of the person in the state. As mentioned, guardianship of the person is much like a power of attorney for health care. It allows the person to make personal decisions for the patient. It does not allow a guardian cannot send a patient in unless the patient agrees. So in that way, it's unlike a power of attorney. It may allow you to petition the probate court for long-term placement, but this is only in cases of dementia, not mental illness. And lastly, I know there's trusts that may really help some families, and you really need to talk to an attorney about setting trusts up for your estate planning needs, or oftentimes trusts are set up because people who are mentally ill get government benefits. And if you were to give them money, the government would take a payback out of that. So there's certain ways to protect your gifts to others. So I hope this has been helpful. I hope this information will let you know what to expect from a mental health hearing and what a mental health hearing can do for you and your loved one. And thank you very much for letting me come and talk to you. Are there any questions?
Involuntary treatment page, the single page, number 9.
Okay.
The good faith attempt is if the person refuses to sign a release of information, is that null and void then?
Okay.
In other words, that if they won't sign a release, we can't probe.
Oh no, this is entirely different. I'm sorry that I didn't make that clear. This just means that the hospital asks the patient, do you have a power of attorney for health care? And the patient says no. Do you have a declaration for mental health treatment? And the patient says no.
And if they're incapable of answering or giving, they're deeply psychotic or mute or whatever, we can't probe beyond that without consent.
You mean a mental health staff?
Uh-huh.
Well, as I told you, I encourage family members to tell the hospital if these documents are in existence. You know, as mental health care workers, oftentimes you can't give out information, but you can take in information. So the family members can call you and say, hey, he's got a power of attorney and I'm an agent. So to answer your question, yes, you can't really probe. He's giving you an answer and then you can file the petition. But family members in a good support system, which I would assume you only have a power of attorney in a good support system, or maybe it's an old power of attorney, but in those situations, the families are going to be calling and say, we have a power of attorney, or he's executed a power of attorney, or we got this great declaration for mental health treatment. So, does that answer your question?
Well, yeah, except that sometimes they don't want their family to know that they've been admitted. And
well, then you just have to proceed on the involuntary treatment. There's nothing you can do. You have no other avenue at that point because you don't know of the existence of any other document allowing you to involuntarily treat them. So I think you've taken the right path. Usually, if a petition is filed, like involuntary treatment, after we get the petition, we usually need family members to prove our case. So we'll be calling family members, and we'll be saying, do you have a power of attorney? And if that's the case, and we have the power of attorney, we'll turn it over to the hospital, because it's ultimately not our decision, the state's attorney, to accept the power of attorney, because it's more of a risk management decision from the hospital. Is this power of attorney sufficient for our standards, to treat this patient? So oftentimes we'll find out about the existence of a power of attorney. We'll turn it over to the hospital, and then the hospital will recognize it as being valid, use that as their authority to treat the patient, and we'll drop the case. Okay?
Marcia.
Yes?
In terms of, I work at a mental health center. Our crisis team goes out and sees a lot of people that don't have families. And here's a situation we've run into, and there's probably 10 different variations of this. A person who's hoarding, whose house is being wrecked, who is in danger in terms of sanitary conditions, and unable to take care of themselves. But they can present themselves fairly well.
It's her.
So our crisis worker writes a petition, please help us take the person to the ER, local medical hospital, and the physician at the hospital doesn't write a certificate. This happens a few times. Is there any way to utilize the state's attorney in a case like this?
Well,
There's no family.
we as state's attorneys try and get the patient to the hospital, but we're not doctors. The doctors have to give their expert opinion that this person is certifiable. We can look at the facts and say, wow, that really sounds like, that patient's certifiable. But we're not going to testify in the case. The doctor has to recognize after his, the doctor examines the person, and the doctor has to say, yes, this person has mental illness, is symptomatic, and fits within one of these 3 crimes.
Is the state's attorney, I thought in the past they did send out their own psychiatric consultant in certain cases. Is that the Cook County? No.
Yeah, it's not our state's attorney's office. Yeah. I think what happens if you file for guardianship over someone, the circuit court judge will order a Cook County psychiatrist to go out and examine the person, and then give the psychiatrist has to appear in court on the return date for the guardianship hearing, and file a report and tell the judge whether he thinks this person can make personal decisions for himself and financial decisions for himself, or whether, he's a disabled person. So maybe that's what you're thinking of. So. And hoarding in and of itself is not, may not be a danger. It's kind of a difficult one.
It is a call.
Yeah.
Marcia, I have a quick question from
Sure.
someone that they asked. Can you videotape your loved one doing some, when they're in psychosis? If you don't want to call the police, or could you videotape them and bring it to your office?
You can, but our office does not require that much. Our office requires firsthand testimony. What did you see him doing? Where was he standing? How did he raise his arms? Could you demonstrate for the court? So you can, but we don't really have the equipment, especially since we're off-site in many of our hearings. We're going to hospitals for hearings. We're not set up for that. I mean, if it makes you feel like maybe the police will get involved, I suppose that's another question. But we need credible testimony from family observing it, being able to give details about what they're seeing. So I would say it's not necessary from our end, because the testimony of the family is then supported by the testimony of the doctor, who confirms, yes, this person is doing weird things because these weird things relate to his mental illness that I've just described in this way. So the doctor can tie up the behavior to the mental illness. So